with respect to these exceptionally vulnerable children. The recommendation is consistent with the UNHCR's policy on the adoption of refugee children. Of course, such policies can be difficult to oversee on the ground in disaster zones. An application for asylum can be relevant to the exceptions to return in Article 13 of the Abduction Convention. For example, in the Canadian case of AMRI and KER, the Court of Appeal of Ontario found that when a child has been granted refugee status, a rebuttable presumption arises that there's a risk of persecution if the child is to be returned, and thus a risk of harm. The court said that this must be taken into account in the analysis of the Article 13b grave risk exception to return. The Court of Appeal's conclusion was consistent with UK jurisprudence as well. In Re S, Children Abduction Asylum Appeal, Justice Laws said, having regard to the rule as to the paramountcy of a child's interests arising under Section 1 of the Children Act 1989, I would respectfully suppose that a family court judge would at the least pay very careful attention to any credible suggestion that a child might be persecuted if he were returned to his country of origin or habitual residence before making any order that such a return should be effected. In the United States, the Court of Appeals for the Fifth Circuit found in the 2014 case of Sanchez and RGL ex Hernandez that while a grant of asylum is relevant to the question of whether an exception to return ought to apply, the finding under refugee law that the children had a well-founded fear of persecution did not substitute for a finding under Article 13b. The Court also noted that the evidentiary burdens under the Abduction Convention, as implemented in the United States, are stricter than those in asylum proceedings. The circumstances surrounding the cases discussed above have not as yet arisen in Australia, so it remains to be seen how an application for asylum would affect decision-making under the Abduction Convention in our jurisdiction. This is not to say that family law has not had a part to play, and I'll round off this section by briefly discussing the 2003 case of B&B and the Minister for Immigration and Multicultural and Indigenous Affairs. Under the Migration Act 1958, if an asylum seeker arrives in Australia without a valid visa, they must be held in immigration detention until they're granted a visa or removed from Australia. This includes children, though children should only be detained as a measure of last resort. In 2002, two boys aged 12 and 14 made application through their mother as next friend to the family court for orders that the Minister for Immigration released them from immigration detention. The children argued that continuing detention was harmful to their welfare. The trial judge held that the family court had no jurisdiction to make orders in respect of children held in immigration detention and dismissed the application. There was an appeal to the full court which allowed the appeal. I won't go into great detail about the full court's reasons, as complex questions were considered, including intricacies that are specific to the Australian legal system. However, in June 2003, the full court found the trial judge had wrongly decided the court did not have a welfare jurisdiction in respect of children in detention, and said that the court had jurisdiction to order the children be released from immigration detention. The appeal was allowed and the matter was remitted for rehearing. Unfortunately, that didn't last long. The Minister appealed to the High Court of Australia, which is Australia's final court of appeal, where the court unanimously allowed the appeal in 3 separate judgments. In short, the question of whether the family court has jurisdiction in respect of children in Australian immigration detention fell to be decided in reference to the Family Law Act and its relationship with the Migration Act. To date, at least, the High Court has made it clear that children who are unauthorised arrivals into Australia, including refugees and asylum seekers, do not fall within the jurisdiction of the family court. I just want to touch on Australia's role in our region. In the past 40 years, there have been considerable and significant developments in the Asia-Pacific region, and Australia has been seen as having a leadership role. This is due to many factors. We have a family law system and a family court system that is the envy of many states, at least it has been up until now. Our use of family consultants is highly regarded, and innovative practices are seen as best practice, and the thus far well-funded wider family law system is seen as something many countries would like to emulate if they had the resources. Australia has always been a strong supporter of international treaties, and we've been an early adopter of many. Contributions by Australians to the development of the Hague Children's Conventions mean that we're well regarded by the Permanent Bureau, and our advice is sought in our region. A recent example of Australia's regional involvement is our work with Japan. We worked particularly closely with Japan, as did other countries, in the lead up to their ratification of the Abduction Convention in April 2014. And since then we've been working together with the aim of providing co-mediation in abduction cases, mindful of the socio-legal differences that characterise parenting cases in our respective countries. In September 2015, 13 Australian participants, social scientists, lawyers who are trained mediators, and one of the judges of the family court went to Japan, where they joined similarly trained Japanese professionals for intensive training in co-mediation techniques, both for electronic and face-to-face mediation. Some of the participants were also trained in the use of an electronic supervised access module, generously developed by the Japanese Ministry of Foreign Affairs, though this is still in the developmental stage. The idea of supervised electronic access between the child and the left-behind parent is exciting. It will, of course, involve complete control by a supervisor and will hopefully also have the capacity to record the session. We're discussing how to include an interactive game or activity for the left-behind parent and the child to share. We envisage that both the co-mediation training and the electronic access models could be a helpful model for other countries to consider in the future. Reciprocity is utterly essential to the success of the Hague Children's Conventions. There's no international body to enforce compliance or resolve disputes. Accordingly, reciprocity is achieved through active collaboration of contracting states governments. In addition to frequent meetings of member states in which they consider how to improve the operation of the of the convention. Communications between central authorities and judges has proven essential to the Convention's success. As Professor Eston notes, this cooperative approach is unique within the universe of international law and has led us to a new model of international law, a different type of foreign relations carried on by judges and bureaucrats as well as diplomats. The Hague Conference has consistently endeavoured to facilitate innovative systems and practices that enable sound implementation and operation of the Hague Children's Conventions. A very significant example of this is the International Hague Network of Judges, and some of my colleagues from the meeting we've had today here tonight. The meeting we had was of the International Hague Network of Judges. The concept of this was first suggested at the 1998 de Ruenberg Seminar for Judges on the International Protection of Children by now retired Right Honourable Lord Justice Matthew Thorpe, then a Judge of Appeal for England and Wales. The idea involved relevant authorities in different jurisdictions designating one or more of the members of the judiciary to act as a conduit for communications and liaison with the central authorities, with other judges within their jurisdiction, and with judges in other contracting states in respect, at least initially, of issues relevant to the Abduction Convention. The Hague Network of Judges currently includes more than 101 judges representing 82 countries on all continents. The role of a member of the network is to act as a link between his or her colleagues at the domestic level and other members of the network at the international level. There are two main communication functions exercised by members of the network. The first is of a general nature, entailing the sharing of general information from the network or the permanent bureau with his or her colleagues in the jurisdiction and vice versa. The second consists of direct judicial communications with regard to specific cases, not the merits of those cases, but with the objective of such communications being to address any lack of information that competent judge has about the situation and legal implications in the child's state of habitual residence. In this context, members of the network may be involved in facilitating arrangements for the prompt and safe return of the child, including the establishment of urgent and/or provisional measures of protection and the provision of information about custody or access issues or possible measures for addressing family violence or abuse allegations. It can include, for example, inquiries about the status of a re-entry visa or potential criminal proceedings for breaching orders in the other jurisdiction. My colleague Justice Bennett describes this as facilitating a soft landing for the children who are being returned. In Australia, in the absence of any legislative imprimatur, we take the view that there must be complete transparency and procedural fairness where direct judicial communication takes place. We only embark on contacting a network judge in another jurisdiction with the consent of all parties who are fully informed about the nature and extent of the inquiry being made. Typically, a trial judge who's obtained consent would contact the family court network judge, who would then communicate with the network judge in the other jurisdiction. The communication is by email, and the network judges usually reply promptly. The response in the original emails are provided to the trial judge and the parties and become an exhibit in the case. Because of the conferences and meetings the network judges attend, they are almost all known to each other, and the personal relationships are a crucial part of the success of the Hague network of judges. While initially conceived of as a means of cooperation in respect of the Abduction Convention, it is now recognised that there is a broad range of international instruments, both regional and multilateral, in relation to which direct judicial communications can play a role. As you can see from the broad range of topics traversed in the paper, international family law is a vibrant and complex area of law. The innovations of the Hague Conference have created a fascinatingly rich tapestry in which judges and national and international bureaucrats work together for the betterment of families across the world. There are challenges, old and new, to be faced going forward in the 21st century. But if the history we have made together is anything to go by, it will be a very interesting future indeed. Thank you very much.
Thank you very much, Chief Justice Bryant, for a most illuminating lecture. I think we're all very privileged to have some contact with your personal insights in this very important area. The Chief Justice has graciously agreed to take a couple of questions. If anyone in this room has a question, may I ask you to please keep your question short and please identify yourself for the benefit of the rest of the audience. Thank you.
Chief Justice, my name is Robert Edgeton. I'm a practitioner in Hong Kong. Could I just ask this question? Does the Hague network of judges extend to jurisdictions which are not signatories to the Hague Convention on Child Abduction?
It does. It does. One of the things that the Permanent Bureau encourages is for countries who are still considering whether they'll they ratify the conventions to nevertheless appoint network judges, so that there are a number of jurisdictions that have done so. And that facilitates the same sort of international cooperation, even though you may be looking at questions of forum outside a convention.
Thank you.
Perhaps I will exercise my privilege as a chair to ask a question of the Chief Justice. Chief Justice, I perfectly agree with you that the development of international law in any area, whether family law or commercial law for that matter, is always going to be challenging, mainly because international law is not prescriptive, isn't it? It's got to inspire in order that domestic legislatures would wish to embrace whatever has been set out in international conventions. Would you agree with me, though, that family lawyers as a group, as compared with commercial lawyers, are in fact better placed to develop these inspiring family law international conventions? Because we are very used to the idea of family law having to inspire people to behave better.
I'd like to think that was the case. And I think that there are aware of direct judicial communications being involved in cross-border insolvency cases, although I don't think it's anywhere nearly as developed as the Hague network of judges is, and perhaps that's exactly the example of what you're speaking of. That's been around for a long time, but I think what's really developed has been the network of judges, and I think that demonstrates exactly what happens when you have different jurisdictions, civil law jurisdictions, common law jurisdictions, some cases jurisdictions where there might be Sharia law countries and so forth, where there's a commonality of interest about the best interests of children, and that I think does make a difference to both the ability to connect with the other countries and the other judges, and thus the ability to develop the law and the effective measures more than other jurisdictions.
I wonder, a small woman from the University of Aberdeen, I wonder if Chief Justice might comment a bit on her work in the expert group on the grave risk of harm without disclosing any confidential information, but it would be of interest, I think, to know how that work is progressing.
I have to say it's progressing slowly. It's a really difficult task, actually. I think we're finding it quite challenging, but as I said, I've got at least three members, I think, of the working group here this evening. And part of what we're doing, I can't tell you much more than that, part of what we're doing in this meeting, we've got some more tomorrow morning, is to discuss some of the, it's a guide to good practice, so what we're trying to look at is good practices, and it's challenging partly because we do have different ways of looking at things in common law and civil law jurisdictions, and the Brussels 2 bis has some provisions which have to be applied by EU countries which are not applicable in common law countries. All of this has to be taken into account. So, but good practices transcend really all of those things, I think. So I'm sorry I can't be more specific, but just watch this space, I guess.
Perhaps the Chief Justice might comment a little on the challenges faced by the Hague Conferences Malta process.
I'm probably not the best person to talk about that, Selma, because I haven't really had much to do with the Malta processes. You probably know more about it than I do, or just someone else might want to comment on that. But because I've not been to one of those fora, but I mean, in broad terms, I think that the Malta conferences relate to really largely Islamic countries who haven't signed up to the convention. So all I would say about them is that the fact that there are conferences of that kind in countries which feel that, at least at this stage, they're not in a position to ratify the conventions, nevertheless have an interest in doing what they can to foster international cooperation about children.
I would guess that that's also progressing fairly slowly.
Yes.
Moving ahead,
yes,
but fairly slowly. Would anyone care to comment on it? Yeah, actually, I've attended.
Justice Bennett, maybe she was
Justice
at the last
Bennett,
one,
yes, please.
I was privileged to go to the last one because the Chief Justice sent me, but the last one was 7 years ago, and they were intended to be at least every 3 or 4 years. So that is one of the challenges. But Malta has agreed very generously to host another, and that represents not only organisational resources devoted, but considerable financial resources. I think one of the things that the Chief Justice and I appreciate from the meetings that we've had now for a day and a half is something that Lord Justice Thorpe said, and it was in effect, the easy things have been done. What we're dealing now with are the difficult things, and nothing could be truer than the 13.1b. I think they left the hardest till last, and the Chief Justice has got that. In terms of the Malta process, everybody is very enthusiastic about it, but it's one of the hard things. But it's one of the things we want to do, and it's very rewarding, and I think under the Chief's leadership, Australia's going to back the next conference, which will be in May next year, and probably attend this time.
Thank you very much, Justice Bennett. Are there any other questions? I'd like to slide in one more question. You made a very interesting observation, Chief Justice, about the challenges posed by commercial surrogacy. And I'd just like to hear your thoughts. I remember you said that it may be better for us to regulate it in order to be able to control it. Would you go so far as to think that regulating it means that we must go some way towards accepting its legality?
I think that's probably inevitable. I mean, there certainly may be ways of regulating it short of that, or I suppose any regulation assumes some degree of acceptance. One of my major concerns is about the rights of the child, and it just seems to me that Australia as a country could, for example, impose some limits on the ability of parties to bring a child back into the country. They could refuse to allow the child to come into the country if the parents hadn't complied with certain requirements. So you could require that there was the child knew who the mother was, knew who the surrogate mother was, various things like that. And if those things were not complied with, and people have noticed, then you could perhaps enforce it. And I know that's difficult, but I still think there are potentially ways around that. I was thinking the other day, we make the Minister for Immigration the guardian of unaccompanied minors and refugees and asylum seekers, and you could, for example, have the Minister for Immigration being responsible for a child who was entitled to citizenship who a parent, like the twins case, didn't want to bring back to Australia, so that the Minister could bring the child back to Australia and the child could at least be adopted in Australia. I mean, there are things that you can do, I think, if you're thoughtful about them, but you've got to have some interest. But there's likely to be, I've been agitating as much as I can in Australia for there to be an inquiry into international surrogacy, if not domestic surrogacy, and I'm hopeful that we'll have that fairly soon, because I think that Australia's got a responsibility. I think we make up 25% of the market, and it's just, I think it's not really right that we, some people, not everyone by any means at all, but some of our citizens exploit things. Interestingly enough, I mentioned the baby Gammy case. My colleague, the Chief Judge of the Family Court of Western Australia, is at this very moment hearing the Gammy case, because the father and the contracting parents went back to Western Australia where they live. As I said, he's got a criminal record for paedophilia, and the mother, the Thai mother, is now applying for custody of that child. So, pretty interesting case going on at the moment, and I'm sure it'll hit the headlines, I would have thought, when the results handed down.
Thank you. I'm very conscious of the time, so if there are no other questions, I'll ask us all to put our hands together and thank you very much, Chief Justice Bryant, for an excellent Hochelaga lecture. Excellent lecture. On behalf of the Centre for Comparative and Public Law, it is my pleasure to invite all of you to join Chief Justice Bryant in a simple cocktail reception outside this lecture theatre. Have a very good evening, everybody.
Thank you very much. Great, thank you very much. Thank you for sharing. Thank you. My pleasure.